Good morning, good morning, good morning, and welcome to Ask the Expert. Thank you so much for joining us this morning, and I'm glad you're taking the time to learn about how to keep your website secure. One of the biggest challenges, and I've even had this challenge too, is that you pay somebody to write copy on your website, and then somebody goes, wow, that looks really good. I'm going to use that myself. And they steal it from your site and use it word for word. Have you had that happen? And I sat and thought, well, what am I going to do now? I don't know how to handle this. And why are they stealing my verbiage? There's so many more people out there. Why are they coming after me? For what reason? Well, it must have been so good that they couldn't resist it. And this happens all the time. And it happens with people stealing photos. That may happen where it comes right off your website. You paid for the photo, and then suddenly they get to use it. So I think you know exactly what I'm talking about if you've ever experienced this. And if you haven't, and you've done a great job on your website, I promise you, you will. So you're really going to want to listen to what we're talking about today, because I so admire this woman because she does such wonderful work for people. And it's so easy to work with her because you can understand what it is that she has to say and follow through on her advice. And the other thing that she does, which I really love, and I had her do this for me, is to go through your website, make sure you are compliant, because you sure don't want to get into trouble in any way. And I've had that happen too with regard to my YouTube. I don't know if you've ever had this happen. I put songs on my video, and I'm constantly getting messages from YouTube that I'm using other people's music. But I bought it from a service that provides little blocks of music. So all I have to do is say, oh, I bought this from such and so. And then they go, oh, okay, we didn't know. So this today is going to give you a real heads up on how to do your business differently by protecting yourself and abiding by the laws that we need to comply with. So let's get started, and we will bring her on right away so you can learn as much as possible. And welcome back, everybody. I am so excited that you're with us and we get to talk to this fabulous person today. I'm so grateful that she's given us the time to have you here with us. And let's bring her right on. And welcome Barbara Ingrassia. She has an extensive background in copyright law, and she's always teaching the librarians, right, Barbara?
Yes. Yes, I do a lot of work with librarians. Yes,
you do. And
well, I was one. So
yes, and they select her all the time to come in and speak, which says a lot. And she has a major background. Tell us a highlight in your background, Barbara.
Well, first of all, thank you so much, Dr. Shirlene, for inviting me to be with you and your guests today, your audience. I come out of an academic library background, and as print evolved into electronic, I began negotiating licenses, and that rolled over into copyright compliance education for the campus. I have certification in copyright management, digital licensing, and I keep studying. There's always something new. Copyright is like a gray, murky ooze that's always shifting. And the best answer to a copyright question is, it depends. You know, can I do this? Can I use this? They just want a yes or a no, and they don't really want the no, especially if they've already done it. And it depends. Every situation is different, but there are some basic skills that can help control risk, reduce risk.
So, you know, you just brought that risk thing up. You know, risk is always a problem when we're exposing ourselves on the market. And so, I mean, I'm out there. I'm like an open book. You know that because you've done the research on what I do. And people can copy off of my site or steal my pictures, and most of them I take myself, so I don't get into any kind of trouble. Talk to us about where we can go to get photos so that we don't get into trouble, and what to do if we already have photos that we stole from somebody else.
Well, that kind of assessment of your website is an important step to take. There are many more free sites now for images, Pixabay, Unsplash, Pexels, many, but it's always important to make sure that those photos are truly free to use. The internet is such a wonderful resource, and we think about, oh, it's floating around out there, so the creator, the poster, must want us to use it. And they want us to see it. They don't necessarily want us to just take it and use it, even though it's technologically possible. So it's important to look at the source of your photos. Yes, doing an internet search and having hundreds of things show up, and you say, oh, I like this one, and boom. And you might not realize until a letter comes in the mail from an attorney who's not your attorney saying that you have used someone else's property, and cease and desist, take it down, destroy any print materials you've made from it. And by the way, here's a bill. So one caution I want to say is that royalty-free photos are not free to us. The royalties have been taken care of with the photographer. And it doesn't take too long to discover if you go into a royalty-free site and pick something out, and then the little pay screen pops up. Doesn't take too long, but you say, oh, they said that was free. Well, there's free, and then there's not free. Of course, you can license stock photos, but it's always important to look for the terms and conditions. And that's one of the things that you want to make sure you have on your website to protect you and its content. That's a contractual thing rather than copyright, but it helps. So looking at photos, and digging in a little bit, seeing, is it all rights reserved, or is there a license that I could comply with, or is it completely free to use? And there are more and more sites coming for completely free images.
What if you get it on Snappa or Canva or something like that? What if there's a photo there? Is there a problem using those?
Typically, that's part of the library of those sites. But again, it's always important to look at the fine print. Scroll down to the terms and conditions of how you're allowed to use things. Some sites have free images, and then they'll have paid images so that you can tell the difference. But as long as you play by the rules, you're in good shape. And yes, Canva images are good for your banners, social media posts, all kinds of things. And so they already have the templates and the dimensions in place for you to do that. So that's what they're expecting you to do. But always check to make sure, because you don't want unpleasant surprises.
So would we check in the Canva area for whether we can use them or not, or do we check the individual photos?
Well, start with the individual photo, but then probably the terms and conditions for the whole Canva site would cover everything.
Okay, great. Okay. So now I was describing what happened to me with regard to people so complimenting me by using my terminology and
Yes, it feels like a compliment for about a half a second.
yes.
And then you say, hey, you robbed my gold mine. My stuff is my gold mine.
Exactly, exactly. And I'm sure I'm not the only one that's had that happen. So, what is it that we do to, well, first of all, we have to protect ourselves. That's number one. You taught me that. And then, what are the next steps? What do we do if we haven't protected ourselves? Are we just out of luck?
Well, there are various ways to think about it. Some say, well, that's the price of doing business. I'll put some things out there. And that's it's not worth my time to be pursuing it. Now, sometimes it's very special, and you do want to pursue whoever has taken it. Sometimes they don't realize that in the internet age, content that's on the internet is protected by copyright. Mm-hmm. So assume that whatever you find, images or text, whatever, assume that it's protected by copyright until you can determine otherwise. But sometimes people will put together fairly innocently, they're putting together a flyer for a charity or something, and they're not even thinking. So sometimes contacting them and saying, well, that's my property, and would you please not use it? Would you please take it down? Or you could say, please give me credit and a link back to my site. Or you might even say, here's the bill for using it.
It's a bill.
So a lot depends. Now, you can find, there are ways to find who owns that website, where it's posted. You can do a takedown notice, a DMCA notice. As you were mentioning, you get some from YouTube now and then, and you just clear that up. Well, you can have it taken down from the site. And you could go all the way to having a lawsuit. The thing to think about is, even if you win, have you really lost? Because the attorney's fees will cost you something.
Yes.
And you don't know if the thief has the money to pay damages or is even in this country. So it may not be able to enforce the decision. So that's why putting things into place before you put them out can be so helpful. There are measures that you can put in place, for example, the terms and conditions of how people can use what's on your site. Using that C in a circle, where is it here? The C in the circle with a year and your name or your company's name, whatever. And then consider registering that work or collection of works with the U.S. Copyright Office. It's fairly straightforward, online, and very inexpensive. It's sort of one of those stitch in time saves nine kinds of things, or taking precautions. We buy insurance hoping we never need it. If by terrible chance we need it, we're thankful it's there. But if we don't ever need it, do we say, oh, gee, that was a waste. I should never have invested in insurance. So just taking some precautions, making sure your legal ducks are all in a row so that you have a leg to stand on should you want to go to court. For you had the experience of a new website and the terms and conditions and privacy policy and disclaimer didn't come over. And so then, as you pointed out, you weren't protected.
Right.
You couldn't say you weren't supposed to do this because you hadn't told them they shouldn't do this.
Yeah.
And it's hard to believe, but people just don't know, or they're in a hurry. They don't think about that they have a gold mine, for one thing. A lot of people post online and they're sitting on a gold mine and they don't even realize it.
Mm-hmm.
So taking some steps that are fairly simple, and some of them just a one-time kind of step, can really save you time and money and anguish and headaches and nightmares in the long run, and get back to doing what you love, the creating or your business, whatever it is.
I tend to write a lot of articles, and I post them on LinkedIn, and I also post them on my blog. Do I need to have that C on the bottom of every one of them?
It's always a good idea. It alerts people who maybe aren't thinking about it. Also, since 1989, that C in a circle with the date and the copyright holder is no longer required. The moment you have a creative work, a work of authorship in a fixed, tangible medium,
Mm-hmm.
that minute it is protected by copyright. So even, stuff you draw on a napkin when you're inspired in a restaurant, and that kind of stuff, it's fixed. It might be on paper, it might be on your hard drive, it might be audio or video. As soon as it's fixed, and as long as it's original and creative, it is copyrighted at that instant. But because you don't have to have this symbol and you don't have to register with the U.S. Copyright Office, when you don't see the C in a circle, you're not sure. I mean, its absence is not a reliable indication of its status. And that's why I say always assume that whatever you're finding is protected by copyright until you can determine otherwise, until you can determine that it's from a free site, that it's a U.S. government document, that the copyright has expired, those various things, that it can't be protected by copyright. There are certain things that can't be protected by copyright. The kinds of things that are works of authorship, thinking about that broadly. So that's not only text, but music, sound recordings, movies, audio, video, sculpture, even choreography, if it's been set down, the steps in writing. But there are some things that are not protected. Short phrases, the titles of things are usually too short. Common facts, ingredients for a recipe even. Those ingredients are a list, so those aren't protected. Now, the creativity comes in when you say, oh, when my grandmother made these cookies, the kitchen smelled so wonderful. See, that's a creative expression. And ideas are not protected by copyright. It's the expression of those ideas in some fixed medium that is protected. Some things might be protected by trademark. They might be too short, but they become the logo or the business name or the trademark. So there are a couple of other things to take into consideration, but copyright is probably the thing that most of us encounter most often and every day.
What about a name? Like I was using the name Massive Visibility Media Coach, and I got an email from somebody saying, I use the name Media Coach and you can't use it. Is that right? Because isn't that pretty general?
Well, that's true. And that falls probably into a registered business name, which is a state thing.
Mm-hmm.
But somebody who's not in your state wouldn't be thinking about that aspect. So it's probably more of a trademark issue. And trademark exists to protect the public from confusion. If things sound too similar, the public is going to be confused about, well, who's really behind this, and the quality might differ, and so it can damage and dilute your trademark.
Mm-hmm.
trademark goes through different categories, different classes. So we have Dove candies and Dove soap.
Mm-hmm.
Same word, same trademark, but
Very different.
Different categories that they're not going to be confused.
Right.
There are trademarks for goods, products, and then there are trademarks for services. So those are some of the things to sort through. There are some words that can't be trademarked. They are too general.
Mm-hmm.
Typically, a last name can't be trademarked, but because McDonald's is a last name. But we all know what that means. We all know what that brings to mind. And so it's associated with something. And so that has been able to be trademarked. So there are a lot of ins and outs of trademark. The application process can be quite detailed. It's good to have a trademark attorney handling that. And the U.S. Patenting and Trademark Office will do a deep search and they'll say, well, now, does this sound like something else? It's not the exact same spelling, but does it sound similar? Does it imply the same thing? So there are a lot of nuances to a federal trademark. That's the R in a circle. But you can trademark something. Well, first of all, you don't have to register a trademark at all. You can just, draw your line in the sand and say you're using it. Mm-hmm. And that gives you sort of a common law trademark, which could end up being challenged by, say, a federal trademark. But you can also get a state trademark, and that's usually fairly simple and inexpensive, straightforward, doesn't take forever. A federal trademark could take 6, 12, 18 months. And there's no guarantee that just because you've applied that you'll actually receive that trademark. So there are various things that you can do. So you could put a TM next to your logo if it's a product. You could put an SM for a service mark if it's a service. Now, those you can do without any kind of registration. They're more of a heads up kind of thing than having legal authority, but it is a step that you can take. So just as you don't have to register a copyright to have a copyright, you don't have to register a trademark to have a trademark. Now, there are advantages in both cases to registering. With copyright, if you register within 3 months of publication or before an infringement occurs, before there's a theft, then you can sue for damages and probably get statutory damages, which means your legal fees paid. Mm-hmm. So that little bit of effort to register something for, it's about $45 now. That little effort could pay off big time down the road. And if you never have to resort to that, well, you're still good.
So tell me something about when we write books, we have to have a copyright in the book. And how much time should authors allow to get that copyright registered before they actually produce the book?
Well, that's a complicated thing. You can register an unpublished work, and that was formerly not available. But to register a published work, which is the way you probably want to go, the work has to be available for sale, rental, lending, distribution beyond your family and friends. So it's got to be available out there on the market. Mm-hmm. So I advise people to have the form ready to go, and the minute the book is released, send that in.
Okay. And if they're self-publishing, they're expected to do that, correct?
Oh yes, And sometimes when you're working with a major publisher, they'll take care of that step sometimes. But if you're self-publishing, that's something you need to think about on your own. Put in your copyright symbol and date and year, name, which most self-publishers do now. And even people working with major publishers will often hold the copyright, which is an important thing to do. But then to do that registration process is an important follow-up step.
It is important. And I was lucky because I hired Aviva New York to publish my book, and she took care of all of that. I didn't have to do any of it because I didn't want to take the chance that I didn't do something right. You know, it's very important that we do it properly, especially if we're going to release it to the world. And I just decided better to have a publisher do it than for me to try and do it and mess it up.
And so you can search the U.S. Copyright Office database if you just want to make sure that everything went through carefully.
Yeah. Yes. I wanted to make a comment about something that you did recently. I was watching your videos, and you said that copyright law didn't apply to some of the older works like Charlie Chaplin or something like that from the past. Would you tell the audience about that? Because I thought that was so interesting, because we can actually use that kind of thing in our marketing. Is that right?
That's true. Now, in the case of Charlie Chaplin and other things, the copyright duration has expired. Mm-hmm. So anything now that was published in the U.S. prior to 1925 is in the public domain and can be used for any purpose by anyone. Don't have to give credit, but it's not a bad thing to do. For in the U.S., copyright for an individual author, well, it could be a joint author too, but not a company here we're talking about, is for life of the author plus 70 years. So the heirs, if they're aware, have some time to benefit from it. Copyright was instituted in the Constitution to incentivize creators for artistic works, scientific works. So the trade-off was you get a limited monopoly. Mm-hmm. Now that period of time has lengthened over the years, and right now it's life plus 70 years. That's the case in much of the world, but not all of the world. Life plus 50 years in some cases, and that opens up a whole nother question. So in 1998, the United States extended copyright from life plus 50 years to life plus 70 years. That was the Sonny Bono Copyright Extension Act. And in addition, just to make the math impossible, they did some retroactive stuff. So you say, all right, anything published prior to 1925, but 70 years and whatnot, and then the math doesn't work because the way that legislation was instituted. But that means that for 20 years, between that 50 and 70, for 20 years, nothing came into the public domain in the United States. Mm. So the Charlie Chaplin silent films, sheet music, literature, art was dormant. There was a drought in the United States for 20 years. And finally, on January 1st, 2019, the gates opened. In fact, I had a little New Year's Eve party before January 1st.
It's really cute.
So things like Charlie Chaplin silent movies. But again, you have to be looking at the date and at the originals. Uh-huh. So, for example, some Sherlock Holmes stuff is out of copyright, but some isn't. So you have to be careful not to use any characters that came in, after 1925. The Prophet by Gibran came into the public domain in January 1st, 2019. And almost immediately, you saw republished works, adding commentary, various things. So there's some things they were just really ready to go with.
Yeah.
Public domain works. Once you're in the public domain, you can't put a copyright on them. You can copyright everything that you've added around it, but the public domain work is not protected. And so anybody can use it.
Yeah, I saw that with one of Napoleon Hill's works.
Yes.
Yes. And I can't remember her last name. Sharon, do you remember her last name? Put all kinds of comments in Napoleon Hill's work, which for me didn't have near the quality of what the message was from Napoleon Hill, but she got it out there with his name, which is a pretty cool idea. But we've come to the end of the show. It goes so fast, doesn't it? And you gave us fabulous, fabulous information. You have a new little ebook out that's a guide, don't you? Can you show that to us?
5 steps to guard your
goldmine. Put it over a little bit to the right. There you go. 5 steps to guard your goldmine. And Barbara, tell us a bit what's in that.
Well, some of the things, 5 steps that you can take, not the only 5 steps, but things to be thinking about. Your website is the heart of your business. You're directing all of the traffic from social media and blog posts and wherever to your website. So protecting that is an important first step. So looking for, as you mentioned, what images might be on there that you don't know where they came from. Checking that out, maybe making that a change. Are the terms and conditions there? Also, we talked about finding free images. That goes along with that. How copyright law applies. And we've talked about that a little bit. As you can tell, I have sort of a passion. And I could talk all day. And then how you protect your ideas and the fact that you need to capture them, express them, and capture them. So those are some of the things that I discuss in that little ebook.
Okay, wonderful. And I have this little guide that she provides, and I absolutely love it because I can refer back to it when something pops up. And believe me, things pop up. If you haven't had things pop up, you're not out doing enough business, let me tell you. And so this really helps because I can look there and say, am I doing this right? Or does this person have a right to do that? And I just want to thank you so much, Barbara, for being with me today and for sharing all this with our audience.
Well, thank you so much for inviting me. It's been a real pleasure.
You're welcome. So thank you, everybody, for being with us today. It's been absolutely wonderful having you. I hope you got a lot of really good information. I try to bring you the best of the best. And Barbara Ingrassia is certainly one of those with Guard Your Goldmine. Each one of the people on Ask the Expert comes from the Authors and Speakers Visibility Playground on Facebook. So if you're an author, a speaker, or a provider who benefits those 2 genres, please look into joining us, the Authors and Speakers Visibility Playground. See you next Friday with another fantastic heavy hitter from our group. Bye-bye.